have two distinguished guests on my YouTube channel, Conversations with Rudy Rivera. We have Yesenia Vascones and Sergio Hidalgo Monroy Portillo. And I'm just Rodolfo Rivera. I only have two names, you know. I should be lucky to have more names. Ladies first, Yesenia, we're going to talk about the judicial reform in Mexico and why mediation has become a very important component of what people need to do because of the judicial reform. But before we do that, Yesenia, tell me a little bit about yourself, your background, and I'll go to Sergio.
So my name is Yesenia Vascones. I am currently the AVP head of private company D&O claims at Sampo Insurance. So I handle D&O, fidelity and fiduciary liability claims. I've also handled employment claims in the past. Apart from my day job, I also volunteer extensively with the New York City Bar Association, Hispanic National Bar Association, and a few other organizations. And in my past life at the City Bar, I co-chaired the Task Force on Independence of Lawyers and Judges, which is why I became very well aware of the judicial reform issues occurring in Mexico, and also chaired the Inter-American Affairs Committee. So I've been involved a bit behind the scenes, working with a few organizations looking into this mediation interest in Mexico given the reform. So thank you, Rudy. I'm really excited to be a part of this and learn more from you and from Sergio as well.
Thank you. Sergio, tell us a little bit about yourself. I know you've had a very illustrious career in Mexico.
Oh, thanks very much. And thank you, Rudy, for this invitation. And it's a pleasure to be with Yesenia as well in this event. Well, I do have a background, a long background. I worked for 25 years with the federal government, mainly linked to the Ministry of Finance. And throughout those 25 years, I was sort of the firefighter of the Ministry of Finance. So wherever there was a crisis, for some reason, I ended up there. and this is from the financial crisis back in the 80s. I was an international lawyer for the restructuring of the Mexican debt at that time, up to the liquidation of many public companies as well. Sort of the last one was Luz y Fuerza del Centro, which is the second utility company that existed in Mexico. Now there is only one monopoly, which is CFE. Many of you might know it. Yeah. But before that, in the center of Mexico, there was Luz y Fuerza del Centro, and that was probably the most complicated one to implement. And after that, after working for the government, because of course, you know, once you reach a certain level, then it's a political position. When there was a change in government, they asked me to leave the government, and I became the CEO of an infrastructure company, a concession infrastructure company. It was a Spanish company called OHL, which is also doing some construction in the U.S. as well, mainly in Florida and Texas as well. And we sold that company. There was a big crisis in the company as well. So it was interesting that I needed to manage another crisis over there, and did a lot of mediation and negotiation on the assets that were part of the company. And after that, we sold the company to an Australian fund called IFM. And I stayed as the CEO of the company for almost 3 years with the Australian fund. And recently, very recently, I decided to become an arbitrator. This is about 2.5 years ago. And most recently, a year ago, I got a certification to do mediation, which I think that it's the way to go. And we will discuss about that, I'm sure, throughout this panel.
And so people understand my background in this. I've got, because I have this YouTube channel, I talk about a number of subjects, but the reason I found it interesting because I have managed litigation quite a bit in Mexico, as well as other countries in Latin America and Europe, Eastern Europe. And I've been to Mexican courtrooms. I've attempted to do mediations. I've been following the judicial reform because, you know, it affects stuff that you have pending. So that's why I thought this topic, you know, was important. So, I mean, the reason why mediation has become so important now is because of the judicial reform. And the Mexican legal system is somewhat counterintuitive to an American lawyer. Civil law is counterintuitive to an American lawyer. And so, Yesenia, why don't we start with you and tell me briefly, with your experience in Mexico, first of all, what are the changes because of the reform and how that affects you? And then, Sergio, how that reform also affected you.
Yeah. So, as I mentioned, I'm the head of the private company book here at Sampo. I handle mostly U.S. companies, but a lot of our U.S. companies have subsidiaries throughout Latin America, with a good concentration being in Mexico. So we have a lot of claims coming in. Under D&O policies, you have everything from shareholder lawsuits to government investigations, which is the bulk of the claims that are coming in through the door for the private company sphere. Dealing with the Mexican court system was a bit difficult before the judicial reform to begin with. They're usually very long processes. They're usually can be very complex, particularly depending on what kind of government investigation you were dealing with in the court system. After the judicial reform, there's a lot of concern over the politicization of the courts, like you mentioned, Rudy, during our prep call, and also what this will mean for just the process itself. Will we really get a fair shot, whether it be for the insurance carrier who has been brought into the lawsuit, which I'm sure Rudy can talk a whole ton about, but
I can
also,
talk a lot about that, yes.
but also for our individual clients, right? Our individuals who are being sued, who are going through this process, which was already complex beforehand, but now we're dealing with judges who are inexperienced at best, are lawyers at worst, are not lawyers at worst. A lot of the reforms allow people who are not actually part of the judicial process, meaning they're not lawyers, they didn't go through the judicial process school, for lack of a better phrasing of it. I'm sure Sergio can talk a little bit more about it, but there is a whole system in place before the judicial reform to train judges, to give them support. It wasn't the best, but there was a lot of training involved. Now you don't have that anymore, and so you've lost an entire generation of experienced judges who can actually review and talk about these cases at length. So not only have you lost the brain power in that sense, you've also lost continuity with the courts. You truly do not know what you're stepping into in a Mexican court for our insureds, or for ourselves if we're involved in litigation down there.
Right. Sergio, do you have an opinion on that also?
You're on mute, Sergio.
Thanks. Sorry. Let me tell you, my experience is that the judicial system was strengthened since a reform that happened in in the year almost 2000, 1998, I think, was the last judicial reform. And that created the judicial career within the judicial power. And it took us a long way to get the judges with the right preparation, to get a career where everyone was really proud of being part of the judicial system, where you would have people who started as a clerk in a courtroom and 20 years after was finally a judge, and learn all of the process. And that was working really well. Even though, and this has to do with probably Roman law as well, but even though procedures would take a long time, and some of the procedures will start at the local level, but then when you would go to the amparo, they would be revised by the federal judges, who were mainly the ones that were getting all this preparation. The system did work. The system was going in the right direction, I should say. Changes, yeah, there were changes. There could be changes, and mainly because I have to admit, one of the justices in our Supreme Court, they got involved with some corruption, and they were sitting at the administrative organization that would manage all of the judges. So there were changes that were needed, of course, but not this reform that we got. How does that impact me? Which is actually the question. I decided to be an arbitrator, as I told you, 2 years and a half ago. But when I learned that there was going to be a judicial reform and the basis of that reform, which actually were all implemented, and as Yesenia said, disregarding all of the preparation of the people who were part of the judicial system, I decided to become a mediator as well. That's when they presented the reform, that's the day that I said, I need to be a mediator because this is going to be the only way out of this reform.
And out of the law does not allow non-Mexicans to be mediators. As I understand it, you have to be a Mexican attorney to be a mediator, or am I wrong? That's what I read.
Well, now that we get into mediation, there was a recent law. This is in 2024 that it's a mask law.
Yeah, mandatory.
But actually, it's just regulating mediation, and they created this figure of a certified mediator. And if you want to be a certified mediator, yes, you have to be Mexican. Why? Don't ask me why. I don't understand why they included that in the law. And since we have not signed the Singapore Convention, then the only mediation that can be enforced at the judicial power is the certified mediation so far. No, that's the only way you have to go right now.
Well, let me backtrack a little bit to the reform. I honestly, prior to the judicial reform, I felt very comfortable in a Mexican courtroom. But I've been in courtrooms in Prague, Romania. I've been in courts in Mazatlan, San Luis Potosí, Guaymas, Hermosillo. Actually, in the trials, and lawyers I work with say, you're the only client we've had that ever attends the hearings. So I personally felt comfortable with the judicial system before the reform. Now, I understand one of the reasons for the reform was that the president at the time, AMLO, as they call him, did not like certain rulings of the Supreme Court, and we got the majority in Congress, and that's when they changed the law, and that's when everything, fell apart. So I would be prepared or expect that I might lose a case in the first instance. But I felt comfortable that in the revision, which is the first appeal, as you know, and then the amparo, that I would usually win. And that's exactly what's happened in those situations. I was more weary about arbitration. In other words, at that time, I felt more comfortable going into a Mexican courtroom than I would in an arbitral proceeding in Mexico. We can go into that in another broadcast, but that's how I was more comfortable there. So, and some things that I'll go over quickly with the law is when I say it's counterintuitive, it's the case is presented in front of a basically a legal clerk, not the judge. She hears the evidence. If your client is testifying, you can't be there. If the witness is testifying, both of you are there. You can't really cross-examine like you can in the U.S. You have to put your questions in an envelope, and the clerk opens them, and then the secretary will text the judge, come on in, we've got a disagreement, you have to decide. And then you have the alegatos, and then the case is there, okay? So I felt comfortable because the judges at the appeal court were much more educated. And now you have a system where all the judges are elected, and some with no legal experience, which puts the fear in a lot of people. And there are some people say, oh, nothing's going to change. Or some people say, we're going to go into arbitration now. And there are a number of judges who are going to, like the Mexican bar, say, hey, we want to be arbitrators now. Well, that's not easy also. There's a big difference between being a judge where you command and being an arbitrator where, the parties are paying you. So I think the judicial reform is a bad thing for Mexico because it creates more uncertainty, right? And so wouldn't you say, Yesenia and Sergio, that before you had confidence that the judges were going to do the right thing in some form or another? But now you have to do diligence on the judges themselves. Where did they come from? How did they get elected? Who were they associated with? That becomes a whole new facet to basically doing your due diligence, as a lawyer handling the case and the client. What's your thought on that, Sergio?
Well, definitely. I have never thought about it, but yeah, you need to do a due diligence on who's going to be the judge there, and let me tell you what's actually happening. All of the big firms in Mexico are recommending their clients to move to arbitration and mediation. There's still this fear of, well, if I do arbitration, once I have the final award, if it's not complied by one of the parties, I'm going to go to the judicial power again. But there's an institute, the Mexican Institute of Arbitration, that did a wonderful job after the NAFTA was enacted. We're talking about in the late 90s, to educate the judges at that time on arbitration. And if you analyze the cases that were brought to the judicial system, the arbitration cases, throughout all this period, this past period, from the past 25 years, most of them are treated correctly because there was this education process of the judges that would understand arbitration. What's happening now is that the IMA, this institute, is working with the new judges to try to educate the new judges. But it's going to take time. It's not going to be
immediate. It's going to take time because
it's going to take time.
Yeah. You say, what experience have you had with that?
Well, let me tell you. I haven't had an experience with a new judge yet.
Mm-hmm.
I haven't had experience with a new judge yet. I don't know what's going to happen. And let me tell you, I'm just an arbitrator. I do not represent clients on arbitration processes. So I wouldn't be the one to talk about that, because once I bring the final award, that's it. I don't get involved with the judicial power. I don't know if it's going to be enacted or one of the parties is going to try to nullify the award. So I don't think that I'm going to have that experience myself, but many of my colleagues do. And for example, there's one case, Rudy, you and I were in the California arbitration date, and my colleague over there, René Delux, told us an experience that he brought an award to the judicial system, the federal judicial system, to a court in Guadalajara. And the judge over there asked him to submit all of the file of the arbitration, not just the final word. So there's going to be problems. There's going to be risk involved, and it's going to take us time to educate all of these judges. Now, one thing is really happening. The new administrative body that is going to manage all of the judges is very open to listen to comments on judges not doing the right thing. So this is something that we're going to see a lot, and they really want to do at least the most obvious ones. They want to see the judges do the right thing. But
I don't have faith in that.
No, I know.
Because the system has been so politicized that I can see that body as a means of persecuting people who, rule against the government. I mean, that's the reason for the judicial reform.
You're saying that. You're correct. If you're going against the government, then it's more complicated.
Very complicated.
If it's a private issue, then it won't be as complicated.
Well, I still worry about the competency. Go ahead. You say
it's still complicated because that's who has ties to who and what and where within the government, and that's the concern that we always have when we're looking at these kinds of cases. Is, to your point, Rudy, Sergio, before all of this, there was some sort of level of confidence that there was an oversight, that there was training involved. that even if the system takes forever, there's still some sort of comfort level. After this, to Rudy's point, it's a matter of seeing who has connections to what, because this is all an election for these judges. And again, you don't have to have a legal background or any legal studies or training to be a part of this. So how did you get there in the first place? So it's very concerning when we're thinking about our private cases going before these judges. And again, you cannot, and I'm just going to throw that out there. Maybe I shouldn't, but you can tell me, Rudy, if I shouldn't. But there's a huge concern over corruption, and then the FCPA being implicated, and what does that look like for our private cases? And with these judges, again, you can't discount the criminal potential to this being a part of the judicial system, right? In terms of what connections do they have? Are we now having to be more aware of that? Like, there's a lot of things here that has created an uncertainty in the system. And I think to Sergio's point, there is an oversight, hopefully. And one thing that we are being told over and over again is business interests are incredibly important in Mexico, right? To the extent there isn't rule of law or confidence in rule of law, there will not be any more investment. So the government, and hopefully under this particular administration, as opposed to AMLO, there is more concern over the investment, right? And if the investment pulls out because there is no rule of law, because there is no confidence in the judiciary, that will hopefully be a wake-up call, and hopefully they will take those comments more seriously, because especially in the world we live in today with the U.S. political landscape, and again, I'm going to throw out the FCPA and everything else that comes into that, there is hopefully more of an incentive for that oversight, because again, that nobody wants to take a risk right now. I'm starting to see those cases coming in through my door with the government, the U.S. government investigating these things, these kinds of companies that have some sort of tie in Mexico that might have a third-party tie to criminal activities. So,
and I would say, and then we'll move on to mediation. I will say that people look at arbitration as a solution to this, but I see it as a Band-Aid, because I don't think Mexico has enough arbitrators. Okay. And I'm not afraid to say it. The prior pool of arbitrators was a small pool of people. Now European firms are coming in and trying to set up more arbitrators. Singapore is trying to get into Mexico. JAMS is trying to get into Mexico. So I think the pool needs to increase. But now people think, well, we've got this reform, let's mediate. And the problem is that the Mexican attorney is not used to mediating. And historically, what's happened in the past is the client says, well, my lawyer said we're going to win. Why should I mediate? We're going to win. Okay. And the times I've tried to mediate it, I think it was difficult. One almost turned into a fight. Another one was, well, trying to convince me why they're right, I'm not wrong. And so compromise is looked upon as weakness in Mexico. And so that's why I think it's more the younger lawyers who are looking at mediation more than I say like the really older lawyers. Sergio, what's the trend? You being an arbitrator mediator now, what trend do you see happening in Mexico?
Well, most definitely, lawyers are telling their clients include step-up clauses that will include mediation and arbitration. That's what they're telling their clients.
Sure.
I don't know if they know what they're getting into, but that's a recommendation they're doing now, just as a reaction to the judicial reform. Now, is mediation going to actually work, and the step-up clauses, are they going to be taken seriously? Meaning, are they going to jump into arbitration immediately and just exchange letters to say, well, we finish our mediation and that's it? That's something that we will see in the future. My sense is that lawyers not only have told their clients, listen, let's include this type of clauses with the step-up clauses, but they're actually telling their clients, you're much better off reaching an agreement now, because we don't know what we're going to get into in the courts. So,
well, yeah.
So it's going to change, I think. I hear you clearly that when the judicial system worked, and you just said that you felt comfortable with the judicial system, why would reach an agreement. If I have told my client that he's right and he's going to win, no, why would I take him into a mediation?
Exactly.
But now that it's not clear who's going to be your judge, which background he has, is there going to be corruption involved? Because I totally agree with Yesenia that the government argued that this judicial reform, they did it because they wanted to help to have justice for the people. What they don't understand is that they're bringing the judicial system 30 years back, where I used to litigate, unfortunately, and people who have more money were the ones buying the judges. And that could happen again. Could happen again. No?
And it's not just cases against the government, Sergio. It's cases against prominent and wealthy.
Oh, of course, of course. No, in that case, corruption could get to be a huge problem in the judicial system. And I myself have in one case where I am trying to mediate, the representative, the private representative of a judge came to the parties and said, listen, you're better off if you go to the judicial and we have it all fixed for you. So, corruption could get to be a huge problem in the new judicial.
Sergio, I've been a lawyer as long as you have, probably longer, and there isn't anything I haven't seen, okay? So I'll just leave it at that without going into details. But see, I think unless there's a discipline in Mexico for the lawyers to learn how to do it, because mediation is a process in the U.S. For example, in the U.S., you have discovery, and if you're going to win, generally you're going to win. If you know why you're going to lose, you know why. Okay. But that openness and discovery is not available in Mexico. Now, the advantage is that when you are a plaintiff and you file your petition, you have to try your case. When you're a defendant, you have 10 days or 15 to answer, but you have to try your whole case. So at that point, you have people know what's there, but you don't know the little nuances, things that, may not be there, because I think the mindset in Mexico is, well, if they don't know it, I'm not telling them about it. Or in the U.S., you have to disclose good and bad. So to me, that would be the point when you would want to do a mediation. After the answer's been filed, you've had a chance to look at the pleadings, and then you start talking before the court starts setting the hearings.
Yeah. Well, I was just going to jump in, because one of the other things that I think I have struggled, and this is not a Mexico just situation, it's across other parts of Latin America, is to your point, Rudy, lawyers have to come into a mediation, and we do in the U.S. You have a mediator who typically is either a well-known, litigator who goes into mediation, or a former judge who goes into mediation. And the whole point is lawyers have to be willing to expose their weaknesses to the mediator in order to get to the common ground. I always joke, mediation is successful when no one is happy, right? That's the whole point of this. You have to explore and acknowledge your weaknesses to get to the point where you can come to a compromise. And then likewise, for the judges who are not turning into mediators, it's going to have to be a learning curve of you're not in a courtroom anymore. The parties don't have to do what you want them to do. Because in the U.S., I've had a few cases where certain judges in certain jurisdictions.
In the U.S. too.
It does, 100%. And it's a learning curve. And the learning curve is we just don't use you until you figure out your system for being a mediator. I have a question, if you don't mind me jumping into Sergio, because Sergio, you've gone through the certification process, right? In those classes that they try to teach you and certify you to be a mediator, is there anything to address these concerns that Rudy and I are acknowledging here as part of the process, since it's so new to Mexico?
Well, let me tell you, it was a long process. It took me almost a year to get certified. And most of what I heard throughout that year had to do with mediation for family problems, and probably things that didn't have to do with commercial law. So I don't think that the country has the right framework for the commercial disputes yet. But there was a very recent, this is a month, 3 weeks ago, there was a ruling from the Supreme Court that recognized that the mediation process that we have in place now is not exactly what we needed for the commercial purposes. So what needs to happen is that we sign the Singapore Convention, allow U.S. lawyers to mediate in Mexico, allow Rudy to come on and mediate in cases here, and second, the other thing that we need to do is to include a chapter, as we did with arbitration, in the commercial law, el Código de Comercio, the commercial law, so that mediation, commercial mediation, will be regulated over there. And things are moving in that direction little by little. We're pushing all the mediation community. We're talking to different people and trying to push these ideas so that it will happen. This last ruling from the Supreme Court opens the door for that. So I think it's a good sign of what could happen in the country. Now, let me tell you one other thing that needs to happen, because I was surprised to see when I became part of the panel of the ICDR, the panel of mediators of the ICDR. I took the corresponding courses over there. And one of the things that I learned is that the mediation happens not with the parties, but with their lawyers in the U.S. That is something that needs to happen in Mexico. In Mexico, when you talk about mediation, no one understands that you're going to sit with the lawyers of the parties. You understand that you're going to sit with the parties to try to make them reach an agreement. And
well, in the U.S., you sit with the party. The parties are required to attend.
No, I know the parties, but in the U.S., usually they come with their lawyers to the mediation process. And actually, the mediation agreement is drafted by one of the lawyers as well.
Sometimes the mediator drafts the agreement.
Sometimes, yeah. But in Mexico, it was actually in this certification that I took. Forget about having one of the parties drafting the mediation agreement. That's part of the job of the mediator. No way you're going to allow the lawyers to do that. And that is one thing we need to discuss here in Mexico, because once you get the lawyers involved in the mediation process and represent the parties in the mediation process, then you will have a very strong system of mediation. So if we get two things, sign the Singapore Convention plus the commercial code included the mediation. And second, lawyers involved in the process that know that they can get a result for the parties involved and represent them in the mediation process. My feeling is that mediation will strengthen in Mexico and will be a very successful system for dispute resolution.
Well, the training is very extensive in Mexico, 120 hours of training, and you have to do basically some shadowing. It's not an easy process. And again, that's honestly, I think it's too many hours. And what lawyer who has a very busy practice, if he wants to be a mediator, is going to do that?
But we don't want the lawyers to be the mediators. You'll have the mediators, and the lawyers will represent the parties over there. No?
Well, but you're with JAMS, that's different. But with a number of organizations, for example, mediators are practicing attorneys.
Yeah, and it depends on the level of the case, right? The smaller cases tend to be lawyers who are practicing day to day and do it as a side job. And then for the bigger cases, yes, you have the retired judges and the like. But I have a question. I don't know how this process works necessarily, but is it possible to have co-mediators? So for example, on really complex cases in the U.S., when we have insurance issues and we have the normal underlying issues, we sometimes do have co-mediators. So a mediator who is specializing in the insurance part, a mediator specializing in the underlying issues, and making it more productive. environment. Can you do that in Mexico with, let's say, a U.S. mediator? Obviously, it's more money, but for bigger cases, somebody like me, for example, would be willing to pay for that.
You can definitely do it. I've been co-mediator in a couple of cases, and it works really well. And actually, you don't need to be a lawyer to be a mediator in Mexico, a certified mediator. But once you draft the agreement, it has to be signed by a lawyer that helps you to draft something that will be enforceable at the court after if one of the parties doesn't comply.
Yeah, I guess I was asking in terms of, because U.S. lawyers can't be mediators, so someone from the U.S. who has that experience can help the Mexican mediator work hand in hand, so they can use the U.S. strategies a little bit better since they are practiced in it to help the Mexican mediator do that.
I mean, that's a long process. In my opinion, I think that's a very long process, having litigated a lot or managed litigation in those places. It's just that, the first mindset is the client's going to want to pay for it. Somebody like you or me, you're saying, yeah, we'll pay for it, because our cases generally tend to be, cases that have a lot of exposure. However, in the run-of-the-mill cases, maybe not. Where there's a specialty, probably yes. But it's, ego is a big thing. And that's something you have to battle sometimes too, the ego of the lawyers. One key difference between mediation in the U.S. and in Mexico, and Sergio, correct me if I'm wrong, but in the U.S., once people sign the mediation agreement and one party doesn't want to comply with the agreement, then you file a motion to enforce a settlement. The mediator turns it in, the judge turns it into a judgment, and you have a judgment from the court. But I understand in Mexico, once the document is signed by the certified mediator, then the only time you go to the court is if you go seek enforcement. So if you have a mediated settlement for $100,000, the other party doesn't want to pay, then you go to the court to get an order for enforcement. Is that correct?
That is correct.
Okay. Then what I read wasn't wrong. So
and let me tell you, I have a number of colleagues that are mediators and who are not certified. And what they do is they sometimes call us, the certified mediators, and ask us to sign the agreement so one of the things we do is to certify agreements that where you didn't participate in the process. Of course, I have my rules for that. It has to be a real negotiation. I need to sit with the parties to understand that, to make them understand the implications of signing an agreement that is certified and that could be enforced in the judicial power after if one of the parties doesn't comply. No?
Yeah, so that actual agreement is res judicata. Once the mediator signs off on the agreement, it's res judicata. But I think it's unrealistic to take the U.S. system completely and transplant it to Mexico. Because, the U.S. system is less formalistic than the Mexican system. Conflict culture in Mexico favors more formal adjudication, and written procedures. And if it's not written, it's not the law. If it doesn't say you can't do it, then you can do it, And so there's not much dialogue in conciliation and trying to get along and trying to say, let's come to an agreement. We have an expression in Spanish, un mal acuerdo es mejor que un buen juicio. A bad agreement is better than a bad decision. And so how do you think they can change their mind? Because I've actually found, and I know when I go to Mexico again, these guys are going to shoot me. But the Mexican legal community can be very stubborn and slow to change on this thing. And the training that needs to take place, not the certification, but the actual training to sit there and be a mediator and run through the process, that's something that's an art. It's not science.
Yeah, let me insist in this concept.
Okay.
Let me insist, because it's happening right now with the banking community.
Okay.
I'm in conversations with the banking community. And when you sit with the top lawyers of the banks, they don't know what mediation is.
Exactly.
And if you talk to the less senior lawyers at the bank, they don't know what mediation is. So what we have agreed with them is that we're going to generate programs to educate them in mediation, not for them to be mediators. We don't
But to
want them,
learn how to mediate as
but
parties.
but to understand what the process is, and so that they can represent the banks or their clients in a mediation process. Once we have the lawyers, and you said something at the beginning, Rudy, which is true. If you're a Mexican lawyer, you have your client, he's going to pay you for a percentage of the case, or he's going to pay you in hours, and you think he's right in his claims, then why would I go for mediation? Because I'm going to make a ton of money if I take the process, go through the whole process. Once the lawyers understand that they can also do business by representing their clients in a mediation process,
Mhm.
then the mindset is going to change because it's going to be faster and they will take a big bite out of the commercial transaction once they settle the dispute.
Well, we have a question from Mr. Humphrey. Thank you, Mr. Humphrey, for being here. We all know and love Sherman. Sergio, when a certified mediator signs a settlement agreement for a dispute mediated by a non-certified mediator, okay, I know what you're doing here, Sherman. Do the parties have to agree to that in advance? Or does the certified mediator only come into the event of a settlement? Do any issues arise out of this type of arrangement? Is a co-mediation preferred? We already answered the question about co-mediation. So, question, what happens if a case is mediated by somebody who's not a certified? Then is he committing a crime? But I would assume any agreement would not be res judicata.
No, let me tell you, it all depends who you're dealing with. In my case, I have done that a couple of times, but my rule is that I need to sit with the parties, understand the issues, read the agreement that they have drafted, so that I would know that they understand the implications in the agreement, and then I will take them through the whole process to certify that agreement. And once they have understood all of that, then I can participate in the process. So it's not, there are other people, other mediators that might just take the agreement and certify it and do not talk even to the parties. But I wouldn't feel that that's correct. Actually, I think that that's not complying with the law, the certified law, the mask law.
I would agree with you. But Sergio, the training, and you say, I think you would agree with me, the training is not just for the mediators, as you said, Sergio. It's a skill set for the lawyer also. I and Yesenia have to go into a mediation knowing what our top dollar is, knowing what we're willing to walk away from. And sometimes this thing takes all day. For example, from a strategy point of view, I always like to have mediations on a Friday. And I like everyone to be inconvenienced, you know. I like people, if they're both from the same town, it's one thing. But I never want to do a mediation. It's got to be in a neutral place because I want everybody to have to be in a hotel and have to fly out. Okay. And inevitably, most cases settle towards the end of the mediation because it's a slow process. Okay. And you're saying one of my strategies, I don't know if you agree with it, is I never tell the mediator what my bottom line is.
Oh, absolutely not. No.
You never tell the mediator what your number is because the mediator will go work towards that. So that's the training I think the lawyer needs, you know. And the second thing is setting the client expectation, you know, what it's for, what it's going to do. So those are the two trainings I think you really need in Mexico right now.
Totally agree with you.
Are the law schools doing anything to, because again, I've talked to a lot of LLM students here in the U.S. Again, I did talk with one this morning who's looking into getting certified when she goes back to Mexico. But is there talk in the law schools about training the up and coming young lawyers, because to Rudy's point, I think the young lawyers seem more excited, more interested in the idea of it versus the older partners of the law firms. So is there any initiative in the law schools for that to try and help train the culture of bring some of that in the U.S.? Because again, I think a lot of LLMs who are trained in the U.S. through their programs, then doing the work for a year or two afterwards, come back to Mexico with that training. So I don't know what law schools are doing in Mexico.
Yes, it's a really good question. Law schools have implemented programs for arbitration. Most of them have programs for arbitration. Now they will need to do the same with mediation.
But not mediation. They don't have them for mediation. And honestly, I think the mediation training has to come from non-Mexican lawyers. Not that there are Mexican lawyers who've never mediated. I'm sure plenty have, okay? But you want somebody who wants to teach the science of mediation to a practicing attorney. When do you walk away? And when you walk away, do you still talk? Okay, I've had cases in the U.S. where we don't come to an agreement on Monday, but maybe Wednesday, with the help of the mediator, we continue to work on it. See, that's why I think it's great that it's happening in Mexico, but I'm very pessimistic that it's not going to move as fast as we would like it to because of the resistance. So I think we take the people who are willing, work with them, and just move forward, And it's just a question of educating everybody.
Right. And the way I think to do it is industry by industry. I'm concentrating in two industries, construction and banking and finance. I think if we can move ahead in those two fields, then things can accelerate by itself, because these are two things that touch every economic aspect or most of the economic aspects in Mexico.
I'm not as pessimistic as you, Rudy. I mean, I do think it'll be a slow process, but it's just because, again, maybe I'm so biased by the fact that my clients in Mexico are because they're subsidiaries of the larger multinationals in the U.S. or Canada. But when we have a case in Mexico and we're thinking about potential mediation, it's come up in discussions in the background. We haven't gotten to that point where we're looking at mediation more concretely. But one thing that we've brought on is we'll have a law firm, who has local counsel, obviously, in Mexico, but we'll have the U.S. attorneys informing them and guiding them when it comes to these kind of mediation processes. So we're already having those discussions of having the U.S. involvement from U.S. attorneys to help guide the process a bit. I agree with you, Rudy, it's going to take a while, but given the concerns over the reform, given the fact that there's real business concerns over investment, I do think there is a huge motivation to get this kickstarted. And I think the U.S. firms will have more of a say than maybe we realize, just because of cases like my own, right? We're going to have the law firms in the U.S. have a guiding hand in this, even though there's local counsel involved. Egos aside, we're the clients. We're going to have a bit of a say in this, no matter what.
Well, but that's because, Yesenia, you and Sergio understand the value of mediation, okay? And it's something that you can control, you can dictate. Okay, let's do a mediation, but you need two to tango. You need the other side. And that's where the problem lies. If the other side is not a U.S. company, for example, if the other side is somebody that files a bogus lawsuit, because there are a lot of bogus lawsuits in Mexico, just like there are in the U.S. too. Believe me, was a product of a number of them. So I think, that's where the problem is, because obviously you're going to say to your lawyer, let's mediate. And you're going to have your U.S. lawyer there working with a Mexican lawyer. But I think that's the problem, is when you get the plaintiff who sues you and he's told, we're going to make all this money and we're going to win. And the lawyer has it on a contingent fee basis. And no, he doesn't want to settle because he thinks he's going to win. That's where I think the gap is. That's where I think the problem is.
Yeah. But from my perspective, so this isn't going to be a situation where you have the single plaintiffs coming in or the smaller plaintiffs that'll really benefit in the forefront. It'll be the bigger companies that will hopefully lead enough training at that point through that to train the mediators. Because even the best judge in the world needs help and training to become a good mediator. And you do that through actually doing mediations, right?
Mhm.
Sergio, I'm sure you can attest to that you have an incredibly impressive background, but mediation is a whole nother ballgame, just like arbitration, it's just like litigation is, right? So if you have enough of the bigger cases being mediated and slowly training both sides, I do feel like this will trickle down, because that's how it trickles down in the U.S. I mean,
let me tell you, just to support your what you're saying, Yesenia. I was the CEO of an infrastructure company, the largest concession company in Mexico. I didn't know what either arbitration or mediation was. So
Yeah,
it's going to be a process.
look, I remember in the 80s, they were proposing mediation with family law cases. And there was one lawyer in St. Louis who was a father of mediation, pushed it. And he got a lot of resistance from the family law bar, for doing that. So I think in the U.S., it's almost mandatory. In every federal court case, the judge is going to require mediation. In Missouri, where I'm licensed, they all require mediation. And you're required to mediate in good faith and not just check the box. So, in terms of what I would recommend to somebody who's going into Mexico, I would say, yes, have an arbitration agreement, but you have no authority. You cannot invoke the arbitration agreement until you do a mandatory business to business mediation with the two executives who can make the decision. That happens in a lot of big contracts, mostly software contracts, where it takes a year to implement the software. You don't necessarily want to go to court right away. It could happen in a big construction project for the building of an airport in Mexico, but you could say, all right, before you start any type of arbitration, before you file any type of civil action, you have to agree to mediate business to business. And that's just the two business guys talking, because they know their numbers. At the end of the day, companies live and die by the quarter. How's the quarter at the end of the, that, Sergio? I mean, insurance companies don't necessarily live and die by the quarter. We work off of claim reserves. Okay. So it's not necessarily tied to the bottom line, but for a company like yours, it becomes, so that's my suggestion. What's your thoughts on that, Sergio?
Most definitely. If I knew what mediation was, I would have solved most of the problems throughout mediation as instead of going to court at that time. Now that I know, I'm telling everyone, and not only that, let me tell you why I'm talking to the banking community. Not exactly to have a simple loan include a mediation clause, because that doesn't work. You have guarantees that you can execute in the judicial system. No, what you need to do if you're a bank is ask your clients, the infrastructure companies, the big project companies, that they need to include mediation in their agreements with contractors, so that you know that the project will happen and it won't be stuck in a court for 10 years with someone who doesn't know what they're going to rule.
Exactly. Well, at 7:55, one of the things I did mention was it's important to do due diligence now with the judicial reform. And I want to do a shout out to Polaris, which is a company that is going to be sponsoring my channel. They do investigations all over the world. And they actually have boots on the ground and have people in Mexico to do those things. So I would recommend anybody who's going to go into Mexico, do the due diligence before you sign the contract. Once you're in litigation, do the due diligence there. I like to use the metaphor of the song "Paradise by the Dashboard Light" by Meatloaf. You know that song? When two business people get together, they're in love, they're dating, we're going to make a lot of money. And then when things go bad, it's now I'm praying for the end of time to hurry up and arrive. If I have to spend another minute with you, I don't think I could really survive. I mean, that's the reality of it. Well, do we have any final questions from anybody in the audience? I want to thank you for attending. I thought it was a really great discussion. Thank you so much for taking time out of your busy schedules. And we may have to have a part two. And by the way, you're saying you and I may have to go to Mexico and train all these people.
I would be absolutely on top of that. I'd be happy to do that as well.
And I'll be happy to organize a group of lawyers who need to do this type of program. So thanks very much, Rudy, for this.
Thank you.
Thank you, Rudy. I really appreciate it. Very nice to meet you, Sergio. It's great.
Xenia, very nice to meet you. And call me when you go to Mexico. We'll get together. Likewise, Rudy.
Thank you, everybody. It's good talking to you. And we'll sign off until my next week, April 9th. It's private credit. It's a U.S. topic. So thank you.
Thank you.
Thanks a lot. Bye.